Good morning, everyone. My name is Apurva Sharma. I am the founder and principal at GPS Lawyers and Consultants. Welcome to the third of our information series on visa cancellation and refusal. We have with us Mr. Harry Grossman, our senior immigration consultant and accredited specialist in immigration law. Today, we'll be discussing how to maximize the prospects for success at the Administrative Review Tribunal, or ART. So, Harry, could you please tell us what is Administrative Review Tribunal, ART?
Certainly, Apurva, and thank you for the opportunity. The ART is the body that reviews decisions of the Department of Home Affairs to either cancel or refuse visas. It is the go-to body for merits review.
Thank you, Harry. And what type of decisions can be appealed to the ART?
A very broad range of decisions in relation to migration matters, which include refusal or cancellation of visas, refusal to revoke a mandatory visa in relation to a character cancellation, refusals related to nominations, sponsorships, and decisions, of course, related to citizenship applications.
Thank you, Harry. So, what is the first thing that a person should do upon receiving an adverse decision that's reviewable at the ART?
That is, of course, a shocking experience for anyone who's gone through it. But our advice is to read the decision very, very carefully and to note the grounds for refusal or cancellation and the facts upon which the decision maker relies, so that one can be aware of the reasons for the decision, but also be aware of the timelines for review.
Thank you, Harry. And we know when it's about the appeals at the tribunals, timeframes, they matter. So how strict are the timeframes for lodging an appeal at the ART, and are extensions possible? What is your opinion?
Apurva, the timeline for lodging appeals at the tribunal is indeed strict, which means that the tribunal has no discretion to extend the time limit. For most visa matters, the timeline is 28 days.
Thank you, Harry. Now let's talk about the well-prepared appeal. How does a well-prepared appeal look like in the ART context?
Certainly. Upon reading the decision, one should make sure one has lodged a copy of the decision notice, together with evidence of any request for an internal review. One should also gather the required documents, and they include any evidence to support one's claims, witness statements, and of course a strong supporting submission addressing issues of fact and law.
Thank you, Harry. And on those lines, how important is a legal representation at the ART? Are self-represented litigants at a disadvantage?
While proper representation by an experienced migration lawyer or registered migration agent significantly enhances the prospects for success at the ART. If I can say this, Apurva, the migration legislation is complex. It involves the Act, regulations and policy, but a competent migration law practitioner also understands the ART Act itself and the very important practice directions of the tribunal, which must be conformed with in review matters. A self-represented litigant or applicant will be at a huge disadvantage in navigating these complex provisions.
Thank you, Harry. And in terms of strategy and case building through the lens of litigation and immigration law, what do you think are the most common reasons for appeals are unsuccessful at the tribunal level?
In my time as a tribunal member, and I was a tribunal member for some 5 years, I found the following to be the most telling. The failure on the part of review applicants to identify key issues and to address them, lodgement of submissions that were internally inconsistent, failure to provide important and independently verifiable evidence to support claims, and contradictory statements within submissions.
Thank you, Harry. Would you like to describe one of those in detail?
Well, certainly when presenting a partner visa application, it's so important, as indeed in any application, to ensure that witnesses provide accounts which are in conformity with the account provided by the review applicant. And there is nothing more humiliating than having witnesses contradict the very testimony of the review applicant. And it should be borne in mind that in order not to contaminate their evidence, the tribunal member will require them to sit outside until they are called in one at a time. By then, the damage can be irreparable.
Thank you, Harry. Now, let's talk about the practical tips for maximizing success at the tribunal. So, Harry, what strategic mistakes should be avoided when filing submissions?
I find that self-represented applicants tend to launch into major narrative rather than addressing carefully the facts which are in contention. Sometimes even represented applicants provide through their lawyers major dissertations of the law, which really is not what the tribunal is looking for, rather than a concise and relevant submission. Then, of course, there's the other problem of failing to provide documentation in a timely manner. The tribunal is an extremely busy place, and the failure to lodge material within the tribunal's timeframes can only cause concern to the presiding member.
Thank you, Harry. How can appellants best prepare for their hearing?
We would require any client of our firm, of course, to have read the decision, to list the reasons for disagreeing with the decision, to compile a list of evidentiary documents, which we would certainly assist with, to support their reasons for disagreeing, and to give some thought to who they would like to have as witnesses and the role that those witnesses would play. Then, of course, we would assist with a strong supporting statement and, where relevant, coax from our clients any information relating to compassionate or compelling circumstances where relevant.
Thank you, Harry. And based on your experience, can you please share an example, an appeal that succeeded, and what made the difference?
Certainly. We were confronted once with a terrible situation. The review applicant, in a partner visa matter, her relationship had broken down. And Apurva, it had broken down, as you'll recall, because of relevant family violence, in such a way that the review applicant had little or no documents. She was lucky to have escaped the home with her passport. There was no evidence of cohabitation, no evidence of social goings together with friends, of pooling of finances, and unfortunately she had very few witnesses on her behalf. We immediately wrote to the tribunal and requested the tribunal to consider her a vulnerable person within the guidelines of the tribunal and to allow us to represent her in the full sense. The tribunal normally doesn't allow lawyers to speak on behalf of review applicants. In this case, an exception was made. We were able to direct the tribunal to relevant lines of question, and we were able to assist our client in gleaning whatever evidence she could provide of a genuine and continuing relationship before the breakdown, and I'm happy to say a successful outcome followed.
Congratulations on that, Harry.
Thank you. Thank you indeed.
So that brings us to the last section, where we go to Harry for his advice. to someone preparing to appeal at the ART. So one piece of advice, if you were to share, what would that be?
I would be telling distressed review applicants that winning an appeal at the tribunal is entirely achievable, but it requires planning, precision and persistence. By understanding the refusal decision and its reasons, by submitting strong evidence and clearly explaining the case, it's my view that the chances for a successful outcome can be greatly enhanced.
Thank you, Harry.
Thank you, Apurva.
And for a successful outcome, you can turn to GPS lawyers for trusted help if you're unsure how to navigate this process. You can email us at info@gpslawyers.com.au, or you can call us on 03960788315 or 0484520049. The numbers will be there on the screen. Thank you so much for your time, and thank you for listening to us. Have a great day.